everybody, and welcome to Leading Entrepreneurs of the World. Leading Entrepreneurs of the World features entrepreneurs, founders, and business leaders presenting on cutting-edge topics and the latest industry developments. Our goal is to provide the global business and entrepreneurial communities with a window into the minds of those who are shaping the future of the world. Today, we're very pleased to welcome leading biomedical engineer, professor, author, and serial entrepreneur, Dr. Eric Ledet. Eric is a biomedical engineer with 25 years of award-winning translational research experience, 20 years of consulting for the medical devices industry, and 10 years experience as a serial entrepreneur in the medical devices sector. Dr. Ledet is also an award-winning educator who has developed curricula and taught courses on design, product development, and technology transfer. He has served on the medical advisory boards of multiple medical device companies, and he has also served as a grant reviewer on 7 SBIR study sections for NIH and NIDILRR. Dr. Ledet is Chief Science Officer and co-founder of ReVivo Medical Inc. He is also Vice President of Research and Development and Director of the Health Innovation Incubator at the Center for Disability Services in Albany, New York. Dr. Ledet is also an Adjunct Professor of Orthopaedic Surgery at the Albany Medical College. Dr. Ledet, Eric, it is a great pleasure and an honor to have you here with us today to hear more on the very important and crucial topic and process of achieving a successful tech transfer from research to commercialization. Thank you, and welcome to Leading Entrepreneurs of the World.
Thank you very much. Thank you for the great introduction. It is an absolute honor to be here and a great privilege to be able to present some of what I've done over the 25 years of my career. So I'm going to share my screen. So again, thank you for the introduction. Again, I'm Eric Ledet. I am Chief Science Officer and co-founder of ReVivo Medical. ReVivo is a pre-revenue, early stage startup company in the orthopedic and spine implant space. And as indicated in my introduction, I'm also Vice President of Research and Development and Director of the Health Innovation Incubator and Technology Center at the Center for Disability Services. And the incubator is an entity to serve, a resource to serve the local medical device startup community here in Albany, New York. So I'm going to talk a little bit about successful tech transfer from academic research to commercialization. And I wanted to just give a little bit more about my background to sort of set up the context of this discussion and my experiences. So I started my career, first 9 years of my career, working in an academic health sciences center, a medical school and hospital, regional trauma center. There I ran a research program and worked side by side with orthopedic surgeons and had the great opportunity to work very closely with a bunch of medical device companies in the role of a researcher, but as part of the product development process. After doing that for 9 years, I moved to a more traditional biomedical engineering department in a more traditional university environment. And there I did both research and teaching. And a lot of that was related to medical device design and product development. During the 16 years that I was a professor, I also, 5 years of that, worked at the VA Medical Center, a very unique environment, working for the federal government. As a researcher there as well. For about 10 of those years, about 10 of the 25 years, I have also been an entrepreneur. And so there's been a lot of overlap between the institution, the work that I've done for those institutions and the startups that I have been engaged with. And I've worked as a consultant for a number of different companies, both big and small, been involved in about a half dozen startups, but I've been a principal in 3 different startups. And I wanted to draw on some of those experiences to shape the talk today. And most recently, I've just recently made a move to run an incubator, again, as a resource for working with startups. And so it's really this balance between working at a larger institution and a startup that I want to focus on. And so I think the most value for this talk will be for someone who is working in an institution, whether it's a clinician or whether it is a member of faculty, staff, or even student working in a university environment. So with that, what I'm going to talk about is some first institutional policies that are very important and can shape the whole direction that an innovation or that a startup can go. Talk a little bit about the role and importance of invention disclosures within an institution. Talk about patent applications, both provisional and non-provisional, non-provisional meaning a traditional patent application. And then to talk about the process, some things that I have learned over my experiences with doing a spin-off and licensing out of a larger institution. And then looking at how to fund these efforts, both non-dilutive and more traditional fundraising, and then sort of the next steps, what comes after these earliest stages. So institutional policies are very important and can really dictate the options that an inventor might have as far as going forward with their technology. And of course, the most important one of those is probably the intellectual property policy of the institution. And almost all institutions have IP policies for their employees, their staff, their students or trainees or whatever it is. Oftentimes this is very public and can be available on a website. Sometimes it might be available just through a faculty or staff handbook. And sometimes it's actually very specific and there might be nuances of it that are detailed in an employment agreement. And so I think absolutely key, if you work for a large institution, for anyone who works for a large institution, is to understand the intellectual property policy of the institution and exactly what that means. And I'll give 3 examples. And this is not made up. This is from one of the startups that I was a founder of. And there were 3 of us who started the company. Partner number 1 worked for an institution that had no IP policy and did not care about IP. This was an undergraduate focused university. There was very little research going on there, and during the entire history of the university, there had been very little in the way of intellectual property that was developed. And so my partner was told that the institution doesn't care and the inventor can own that. Ultimately, that was confirmed with the provost of that university. And so that was the policy, right? And obviously, as an inventor and someone who's interested in spinning off a startup, that's a very easy policy to deal with. Partner number 2, which in this scenario happens to be me. In my case, the institution owned IP that was developed using institutional resources. So anything that came out of a class, anything that came out of a lab, anything that was either conceived of or reduced to practice using core facilities, the institution owned that. But conversely, anything that was conceived of or invented outside of the university and didn't use any university resources, the university did not have any claims to ownership on that. And importantly, it actually specifically calls out in the faculty handbook for the IP policy that our laptops in our offices were not considered institutional resources. So if I used my laptop for some communication related to the invention, that would not necessarily jeopardize my ownership. And every institution has slightly different policy, so the details may be different, but I think most institutions are similar to what's in partner number 2's institution described here. Partner number 3, this was a clinician, a colleague who worked for a hospital. And in his case, the institution, as part of his employment agreement, it specified that the institution owns all intellectual property. Anything that he invents, the institution owns, whether he used institutional resources or not. And their justification for that was that they suggest that they create the intellectual environment that allows the staff and faculty there to be creative and be innovative and come up with inventions. And I'm going to come back to this scenario later because it comes back in a couple of ways as being significant. So again, partner number 1, partner number 2, partner number 3, three very different IP policies. And I think because the scenario for partner number 2 is pretty typical, I want to talk a little bit more about this. And in particular, decisions on how ideas are developed under this scenario really dictate the ownership. And so let me talk about that just a little bit further. So obviously under this scenario, if institutional resources are used in the development, the institution owns the IP. And if no institutional resources are used in the development, then per the policy of this institution, the inventor owns it. So really the decision here is based on ease of development versus ownership. And I'll tell you, in my case, I literally ran a prototyping facility at the university. And there were many times that it would have been very easy to use that facility to help in the development, to help in reducing the invention to practice. But under this scenario, with my partners for one of the startups, we made the decision that we were going to do things and keep it outside of the institution so that we would own the IP. And what that meant was that the development was actually much more cumbersome and more expensive because we couldn't use the resources that were available in the institution. But again, that's a decision. It's a decision as a company or as an individual that an inventor needs to make. All right, so now you understand your institutional IP policy, and based on that, you conceive of an idea. So poof, comes the idea. And from that idea, you're sure that this is the one that's going to lead to the pot of gold at the end of the rainbow. All right, so now what to do? Again, working in an institution that has some claim to the intellectual property. So most institutions will require someone who has an idea or an invention to do a disclosure to the TechTransfer or Commercialization Office or whatever it is. In my institution, it was OTC, Office of Technology Commercialization. And I think the invention disclosures thing is very important to be diligent about this. I think that as a good member of the institution and following the policies, disclosing ideas frequently and doing this often is really important. Not just new inventions, but also an improvement to a previous invention. If there's something, for example, that an inventor has previously disclosed and then figures out a better way to do it, I think it's important to then disclose those improvements to the inventions. Typically, I think at most universities, most institutions, this is filling out a bunch of forms and sending them into an office. Sometimes that'll be followed by an interview or a presentation. At one of the institutions I worked, there was actually a committee, and what they would do is something that they were interested in, or based on forms that they received, they would actually ask the inventor to come in and make a presentation, almost like a pitch to a committee that ultimately then would make some decisions. So the university reviews the information provided during the disclosure, and ultimately the institution will determine the value. Is owning the intellectual property, is owning the IP worth the cost of a patent? We'll talk more about patents in a few minutes, but obviously patents are not free. And so the university is going to make a decision whether there's value there or not. And one of the things that's important is to remember what motivates the institution, right? So an institution is not going to manufacture products, put them out in the market and try to sell them, right? That's not what they do. What an institution wants to do is to generate intellectual property. They want to generate patents, and they want to license those as quickly as possible and generate a royalty. And then they call that a success without having to put much effort into it, right? And so if the university decides that it does want to keep and prosecute the IP, it will ultimately own it. And if the university decides that it won't, it will give up the IP to the inventors. And one of the things that I think is very important is being honest and forthright and comprehensive with the disclosure. And that goes two ways. I think not being overly optimistic about what the value of an invention is important. But also I've had colleagues who have said, you know what, I'm going to take it on the disclosure forms. I'm going to make it sound like this has no value so that the university won't hold on to the IP. They'll turn it back over to me, and then I can do whatever I want with it. I think generally that's a very bad idea. I think that later on down the road, that potentially comes back to create problems for the startup and for those inventors if they weren't completely forthright and diligent in their disclosures. So I think being very honest and forthright and comprehensive is really important. So if the university decides to prosecute and keep the IP, there are obviously pros to that. The pros, kind of like what I was talking about with the prototyping facility, are that the institution will then allow access to the resources. And that includes everything perhaps from attorneys to the Office of Technology Commercialization to help develop and market those ideas. The institution obviously is committing to paying for patent costs if it goes through and prosecutes a patent. Those are non-trivial. The institution may have internal programs, seed money or something like that, or programs, whether they're student-based or professional-based programs to help further develop the intellectual property. Obviously, the downside of this as an inventor is that the institution controls the process, and the institution ultimately owns the rights to that IP and the rights to the revenue stream. Now, many universities have revenue sharing where inventors will get some fraction of any money that comes back to the university or the institution as a result of a royalty. But that generally is not going to be 100%. It'll be some small fraction of that. So there are pros and cons to the university keeping the IP as an inventor. If the university gives up the rights to the IP, obviously then the inventors can own the rights to the IP and the revenue stream. However, the institution may not be so helpful. And in fact, in one case, and I'll talk more about this in a few minutes, out of my academic research came a disclosure that ultimately went to a patent. The university decided that they did not want to prosecute the patent. They didn't want to own it. So they turned it over to me, but they said, oh, by the way, now that you own the rights to this, you can't continue to do that academic research. And that was very problematic for me. And I pushed back on that. And I said, wait a minute, just because you as an institution don't think that there's value in this IP, you're telling me at that point as a tenured professor that I have to kill my research program. And we ended up going back and forth and negotiating that point. And ultimately, with a conflict management plan, I was able to continue to do the research and own the IP separately. And I'll talk more about conflict management plans in a couple of minutes. So there's pros and cons to the university keeping the IP versus the inventors getting the IP. And one of the things is that oftentimes an institution will take a long time to make this decision, to decide whether they want to keep the IP and prosecute it or whether they want to give it back to the inventors. And sometimes, depending on whether a public disclosure has been made or not, there may be 1 year to ultimately make a decision on who's going to file the patent. And there have been horror stories about how an institution has sat on the IP until the 364th day and then ultimately says to the inventor, we don't want it here, you can have it. And by that time, of course, it's too late to try to do anything within that 1 year window. So as an inventor, I would recommend very strongly following up often with the tech transfer office and finding out what the status of that is. All right, so whether working independent of the institution or with the institution, a provisional patent is a very powerful tool for an inventor. A provisional patent provides some protection for an invention for 1 year. It basically gives the inventors 1 year to decide, do I want to convert my invention, my provisional patent application, do I want to convert that to a non-provisional, a traditional patent, if you will, or do I want to abandon it, right? And so the reason why this is a powerful tool is for a couple of reasons. One is that in an academic setting, oftentimes public disclosure is important. As an academician for a career, it's often important to make a presentation, to publish a paper, to give a talk, something like that. And so that constitutes a public disclosure. And the minute an inventor makes a public disclosure on a technology, it becomes very hard to patent. So if a public disclosure is imminent, a provisional patent application can be filed literally on the day before the disclosure is going to happen. There is some value to getting an attorney involved in this process, but you don't need an attorney. An inventor doesn't need an attorney to do a provisional patent application. I've done many provisional patent applications where we've taken literally pages out of notebooks. We've taken a draft of a manuscript, PowerPoint slides, from a presentation or an excerpt from a grant application. You literally take that, put the appropriate cover pages on it, add one paragraph or so of language, which is pretty easy to do, and file that as a provisional. And that's it. And there's some protection that is there. So the process is not difficult. The link that you can see in the slide there is to the USPTO, the United States Patent and Trademark Office. And that link goes through the provisional patent application process, which is pretty simple. So one of the big benefits is that this can be done very quickly. Number two, very easily, don't necessarily need an attorney to do it. And number three, it's very inexpensive. The filing fee for a not-for-profit or for a small business, a startup, is $150 as of the time of making this presentation. And for a micro entity, there's a specific definition for that, but let's say, for example, an individual. For a micro entity, the fee is actually $75. So for $75 or $150, a few hours worth of effort, it actually, provisional patent application is a very powerful tool for protecting an invention. And so I found that there's a lot of value in doing these often, doing provisional patent applications often. If you do multiple provisional applications on the same technology, on the same invention, ultimately they can all be combined or collapsed into one non-provisional, one traditional patent application. And so what I've oftentimes done, and there's a lot of value in this, is to come up with what I would call the preferred embodiment, meaning the best version of the technology or invention, disclosing that in a provisional patent application, and then coming up with a whole bunch of alternatives. Even if I don't think those alternatives are better, if there are potential alternatives, things that ultimately a competitor might try to come up with, by including those in the provisional patent application, and then later on, perhaps in the non-provisional application, it offers a lot more protection around the preferred embodiment. So rather than just patenting and protecting one small piece of patent space, protecting a much larger piece around that. It also allows, if you do multiple embodiments, multiple different versions of a particular invention, early stage, an inventor may not have an idea of what direction the technology is going to go. Which one of several different ideas might actually be the best one? And by filing on several different ones, you have now this year to figure out which different embodiment might actually be the best one, and therefore that is still protected in the provisional. So the more embodiments that are disclosed, the more protection that the provisional and later on non-provisional offer. And just as an example, these are just some drawings from a patent application that I submitted for a product. And what we have is we have a whole bunch of different embodiments, and each one of these drawings is a different version. And when we submitted this patent application, we didn't know which one of these different versions, which one of these different embodiments is actually going to be the one to rise to the top and to ultimately be the commercial embodiment. And what I've shown you here is actually about half of the figures. You can see this last one is labeled figure 61. We disclosed a whole lot of things. It does make the patent a little bit more complicated, a little bit more expensive, but there are some definite advantages to including this many disclosures. Patent Office will come back likely and they will say, you've disclosed multiple inventions here, so you need to choose one for this particular patent application. But by the time the Patent Office comes back and says that, typically enough time has passed by that an inventor is likely to know which one of these or ones of these they really like and will go forward as the preferred embodiment. So again, multiple embodiments, a very good strategy. So while the provisional patent application is, once it's put into place, there's a year that it protects. And really that year, instead of being 12 months, it really boils down to about 9 or 10 months, because if an inventor decides to convert the provisional application to a non-provisional, that actually takes some time. A non-provisional application obviously is much more complex and takes a lot more time and can't be done in a day. And in my experience, a few months is a reasonable amount of time to prepare for a non-provisional traditional patent application. So what does the inventor do during that 9 to 10 month period? I usually think of a provisional patent application as being the moment that the doors on the starting gate open. And that is the time now to launch out and to start running. And during this year period or so that a provisional protects an invention, it is an opportunity to refine the design, to figure out whether it's going to work or not, what embodiment is going to work, and figure out whether the technology is worth going forward. It's an opportunity to validate the need, to make sure that there really is a market need and that this makes a good business proposition. Just because something is patentable doesn't mean that it's going to have any value from a marketing standpoint. And then obviously, as I described, to figure out which embodiments are best for the commercialization. And as part of this process during this year, conducting due diligence, looking out to see what what competition is out there, what the size of the market is, looking at the IP, looking at the patent landscape, seeing what other patents might be out there to prevent this from being awarded as a patent, making sure that the products can actually, the technology can be manufactured. And as a medical device, it may be very important to look into the regulatory pathway. You know, all of these really have to be there and be ready to go in order for this to have any value moving forward. And if any one of these is a major landmine that could actually cause the whole prospect of going forward with this as a business and a patent to head into the toilet. So this, again, this 9 or 10 months is really not a lot of time for doing all this. And of course, one of the questions that the inventors need to ask themselves is who is going to put in this effort and how will it actually get done? So when going through and refining the design, the goal is to reduce risk and add value. By reducing risk, this is very appealing for future investors or for someone who might want to license the technology or buy the company. So continued development of the technology reduces risk, it adds value. During this time, refining the design is also an opportunity to make a physical prototype or proof of concept or demo unit, or what some people will call an MVP, minimum viable product. Basically a way for you to make a physical demonstration that an invention actually has value and can work. This is very valuable for demonstrating to someone for a future license or for demonstrating to investors to actually show them the concept. During this process of refining the design, it's all about testing, looking at evaluating the results of those tests, refining the design, and then going back to that loop over and over again. The FDA requires verification and validation. I'm not going to get into the details of what that means right now, but essentially establishing the efficacy and safety of the product. And I think one of the things that's often overlooked is manufacturability. A lot of times new technologies might be really slick and a prototype can be made, but when looking at scalability, manufacturing could be a huge challenge. So a question of, is it manufacturable? And if it is, what is going to be the cost of goods? Will that make it competitive in the marketplace? Who can make it? Are there third parties? Are there fabrication facilities, for example, who can make it? And is there just one in the world that can do that, or are there redundant contractors? And obviously for supply chain issues, it's really good to have multiple contractors who are capable of making the technology. So, you know, who does this? Who goes through and does this due diligence, refines the design? How does this happen? So when an inventor keeps their day job, so to speak, at the institution, things like this generally are done in the evenings and weekends. And I think that there's a lot of value in developing many different concepts and taking these through computer simulations before even making a physical prototype. So what you can see here, again, an example of a different product that sort of started out very crudely on the very left image. And we refined this in the virtual world, ultimately doing some testing. This is a computer simulation called a finite element analysis, where we're simulating mechanical loads on this device and trying to decide whether it can actually withstand those loads. So through this analysis, we would go back and refine the design and refine the design and refine the design. And every time we refined it, we would file a provisional patent application so that every new feature, everything that was added to it was covered in some provisional, and we had protection of the ideas of the invention. So then, you know, coming to a point, making a major decision here of who is going to own and develop the technology. And I want to talk about 3 different options here. So option number 1 is that the university owns it, as we were just talking about. And the university ultimately develops it. And the inventors keep their day jobs, right, as employees of the institution. And there are a number of pros and cons associated with this. Some of them, again, in my case, as a biomedical engineer and faculty member in a school of engineering, I had labs, I had institutional resources, I had students, I had fellow staff and colleagues. Basically, you have all these resources at the university. If the university owns it and decides to develop it, and I keep my job at the university, then I have access to all these resources. Of course, it's very low risk to the inventors. Inventors have not really given up much, not a lot of risk there. But the downside of this is that the institution controls the development, and as we were talking about before, ultimately the revenue stream as well. So option number 2 is to spin off a startup and license the technology from the institution to the startup, and have the startup develop it, and yet the inventors keep their day jobs. And so this is really a balancing act. As a faculty or staff member or student or whatever, is balancing the work that needs to be done to maintain our day job, but then ultimately adding value and moving forward with the startup as well. So again, some pros and cons here. Very low risk, no paycheck potential being lost here. The inventors still control the development, but are doing it outside of the institution. And so maybe under that scenario, no institutional resources can be used. And the challenge there is maintaining that balance between the startup company and the institution, and making sure that that does not get out of balance. And of course, option 3, licensing and spinning out a startup, and the inventors leave the institution and go to work for the startup. And so the upside of that is that obviously startups are very nimble, can move very quickly. I don't have to worry about getting lost in a larger institution. The full focus then is on the startup, from the inventors. But of course, there are a lot of cons, associated with working for a startup. For me as a tenured professor, it was difficult to conceive of leaving that position and going to work for a startup that might only have limited funds available, a year's worth of funding available to keep the company going. That's a conversation, it's a family decision for me. It was a very personal and family decision to make, whether to keep my job at the institution or to go to work for the startup. And I think what I want to do is to focus a little bit more on the university startup balance scenarios, number 1 and number 2 here. In particular, number 2, a balance between keeping the startup independent of the institution, but maintaining the day job. So when spinning out a startup from the institution and keeping the day job, the challenge here really is there's a few things, but one of them is sharing time between the startup and the university. And I think it's very important for an inventor to know the policy and the amount of hours that they are allowed to work as a consultant. So example at my institution, we were allowed to spend 8 hours a week doing outside professional activities. Many colleagues would do consulting work. For years, I did consulting work as well, and ended up giving up the consulting work and then spending that time working on the startup, and therefore making sure that I'm not violating an institutional policy by spending that time working with the startup. One of the things that I was able to do was to time the critical development of the technology at the company with a sabbatical. I had a sabbatical coming up that I was eligible for and was able to request that and ultimately get it at a time that coincided with a really critical time for the startup. So effectively for a year, I was able to work full-time for the startup while not jeopardizing my, my institutional position. And of course, if that timing doesn't work out, some institutions, some universities will allow faculty member, staff member, whatever, to take a leave of absence, or even a student to interrupt their education and to take a leave of absence if they want to go and focus on the startup. So a few different options for sharing and balancing time between the startup and the university. One of the things that I think is really important is complete and total transparency with the institution. Whether technology comes out of the lab and goes through an institution, or whether it's done completely independent of the institution, I think it's very important to have complete transparency, to do a disclosure to the university, whether they have rights to ownership or not, to let them know that this is going on outside. And a lot of institutions will require faculty, staff, and students to do exactly that. And if it looks like that there is going to be a conflict, then an institution should engage, and an inventor should engage in a conflict management plan. And this happened to me in the scenario where technology came out of my lab. As I mentioned before, the university decided not to pursue it. They gave it to me and my co-inventors. We did prosecute the IP, a patent was issued, and we formed a startup company, right? So now I have research going on in my lab that in some ways overlaps with the goals of the startup company and the technology and products that the startup is developing. So in the conflict management plan, there were provisions in there for what university resources could and could not be used for what students could and could not be used for how my time could be split between the two entities, and what would happen to improvements in the IP. For example, the company owned the rights to the fundamental patent, but if something happened in my lab academically that generated an improvement on that IP, who would own the rights to that? That was all in the conflict management plan. And one of the things that was important was making sure that there were provisions in there that required the inventors to disclose to the collaborators, to any collaborators, whether that's students, colleagues, whatever, the potential for a conflict. These are generally done by working with human resources or TechTransfer office. And I was very proactive in my case. Someone had indicated to me, you know what, you might want to make sure you keep yourself out of trouble and go and do this. I actually started with my vice president for research and asked that person, you know, how do I proceed with this? Ultimately ended up working with human resources in my institution to generate the conflict management plan. And I will say that one of the things that really surprised me with this was that the emphasis of the plan was really students. And I wasn't expecting that. And what I mean by that is that the plan really laid out in great detail what it was trying to prevent was that a student at the university could not basically work as free labor for the company. And that was the major concern of the university. And that surprised me. I mean, I certainly understand why that's important, but I didn't think that would be the most important piece. And so this is what conflict management plan looks like. You know, it's literally a memo, you know, between human resources and me. This got updated every year, annually. This was updated, and I had to report monthly any changes in the conflicts. You know, and under the Institute's policy and applicable federal regulations, some of your external relationships, activities, and interests are defined as conflicts of interest that must be managed in order to minimize or eliminate any real or perceived bias on your role in the design, conduct, or reporting of research, or to mitigate other potential influence on your objectivity. So this is the crux of the plan. There were several provisions that were laid out in here. I'm not going to go through them in detail, except one thing, again, going back to the student part, was that I was required at the beginning of every semester for any student who was working for me in the research capacity, not students who were in classes that I was teaching, but working with me in the lab, doing research on a project. I had to actually disclose this to them, make this statement to them, and then they would acknowledge. They actually had to sign indicating that I had disclosed to them the potential for a conflict. And I'm not going to read this verbatim, but basically what it says is it's telling the student that the primary goal of their work, their research, their project, whatever it was, is to move forward the education experience for them. But in the course of doing that, they might have some breakthrough in technology that could benefit the intellectual property that I owned. And so primary goal, education, but something secondarily could come out of that, which is a benefit to the company. So that was the main crux of the plan. And I think it's very important, again, for total transparency to work with the institution to generate this. All right, so, you know, now the opportunity has come up. There's now an invention, made the decision. I'm going to do this independent of the university. Let's spin out a startup from the institution. Let's incorporate. So we're going to form a partnership, an LLC. I know that there are websites that are available that can go out and do this for almost no cost. I have always chosen to use an attorney just to make sure that I get this right. It's very important to get this done right from a liability standpoint. In my experience, it's always cost around $900 to go and actually incorporate. On the right, I have a picture of Delaware. I live in the state of New York, but all the attorneys that I've worked with have indicated the benefits of incorporating in Delaware. And there's just several levels of enhanced protection from liability and going through Delaware. I'm not an attorney, so I'm not going to try to get into those in depth, but I think that's certainly worth exploring when an inventor is incorporating. I think the other thing that's very important at the time of incorporation is to institute an operating agreement. And this is basically a set of bylaws and governance regarding the way that the partnership is run. I think it's very important to do that. By laying out those bylaws, it helps in the future if there's ever a situation that occurs that is unexpected. And those bylaws in the operating agreement can be very helpful. And I'll come back to a specific example where that affected me in one second. I think it's also important at that time for all of the members of the company, all of the partners, to assign future IP to the company. Oftentimes, a patent is the only asset, or the intellectual property portfolio is the only asset of a startup. And ultimately, we don't want to have the partners working against each other by holding on to the intellectual property. And I think one thing that is really important, when I've gone out later on looking for investors, and we've had these policies of assigning IP to the company, they've said, well, wait a minute, you also work for an institution. Does that conflict with your institution's IP policy? And we would say, no, it doesn't. And they would say, we want you to actually get in writing from the institution that your IP policy for the company does not conflict with that for the institution. And so we went and we actually got those, and that was something that investors were very happy to see. And I think it's very important then to make sure that there's no activities that the company does, for example, using institutional resources that might violate that IP policy. And one other thing that has turned out to be very important, and I think this may sound very trivial, but opening a business checking account for an early stage startup is really important. Having each of the partners in the business contribute by capital call, and then having all expenses come out of that checking account is much better for tracking contributions and preparing financials. And investors later on will want to see this. And it makes it much easier than saying, okay, well, this person paid for that out of pocket and that other partner paid for that out of pocket. That can get very ugly very quickly. So although it seems trivial, I strongly recommend it. All right, so company is formed. Now it's time to go and perhaps spin out the startup from, or license the technology from the institution. As a startup, it's with early stage funding is very important. Going and finding a lawyer to help with representation in the licensing agreement can be expensive. But I think it's also extremely important to find legal representation. The university will have legal representation. It's important to have an experienced lawyer on your side to help negotiate this. If you want to know what an agreement looks like as an inventor, I would check out the Carolina Express Agreement. This is available publicly. It is an agreement, a boilerplate agreement that came out of the University of North Carolina, Chapel Hill, if I remember correctly. And it's basically all the different provisions that might go into a licensing agreement. So it's a good example for an inventor to look at to see what things to consider and ultimately to work with the lawyer to help in the negotiation. And some of those things include cash up front, who's going to pay for patent expenses, what kind of equity or royalties will the institution want to give up the rights to that? Are there minimums required in a certain amount of time? What are the timelines for hitting certain milestones, things like that? A good tech transfer office wants the startup to be successful. And so they are not going to push these beyond a reasonable limit, but the university also wants to maximize what they get out of this. And so it's important to have good experience in negotiations on the side of the startup. And this is what the Carolina Express Agreement looks like. Again, this came out of North Carolina, Chapel Hill. And there's all kinds of provisions, in here to license and different things to consider. So I think this is a really good place for someone who's new to startup worlds to see what one of these agreements can look like. All right, so now as a startup, as an inventor, the inventor has filed a provisional. They have done work during that year period or so to assess the initial feasibility. It looks like there is a market need. Prototype came out pretty well. And now it's either licensed from the institution or let's say it was developed completely independently of it. What's next? How to build value for that? And I think, as I said already, an intellectual property portfolio, building that as an asset is very important. So converting that provisional to a non-provisional patent application, and those issued patents are a huge asset, adds to the valuation of the startup. So the non-provisional patents, again, filing often builds the value for the company. These are not trivial, not like a provisional patent application. The timeline from when a non-provisional application is submitted until the first office action, the first response, right now at the time of this presentation is somewhere between 24 and 30 months. So that's a long time. So if you're looking at how long will it take for us to find out whether we can get a patent awarded or how strong the claims are going to be, that could be 2 to 2.5 years. Recently, the United States Patent and Trademark Office has instituted a fast track option where for a fee, the patent can be reviewed, patent application can be reviewed more quickly, and the review is done within a year. There's a lot of value to this because it's an expedited process, but there are some risks associated with it in that because the process is expedited, there have been cases that have come up where the patent ends up being not as robust as if more time was taken to do it. So again, some trade-offs there on how early, how quickly, how much value it has to get a patent quickly versus one that might be stronger but comes later. I think these are filing patents and going through this process are very expensive. Most of the cost comes in paying the attorneys. So with search engines like Google Patents, it becomes much easier for an inventor to actually do a prior art search, at least a preliminary prior art search to see what else is out there. And I also recommend going directly to the USPTO's website to search for patent applications. I found that Google Patents, that site is a little bit slower to get applications, not issued patents, but ones that are still in the application process, to get those up, whereas the USPTO has those a little bit sooner. And I think that there's value. Not everyone would agree with me on this, but paying for a professional prior art search. These, in my experience, are anywhere from about $1,000 to $2,000. You're paying a firm to do a professional search and to find all potential references that are out there, or at least many, many potential references that are out there. What's frustrating is you're paying $1,500 or so for this. If they find a reference that ends up pushing you in a direction where you don't think that your invention is patentable, you've paid $1,500 for this. However, the alternative of not paying this $1,500 and coming back later on and finding that same reference, let's say when you get an office action, at that point, an inventor may be $10,000 into the process. And so I actually think that there is a lot of value in paying for a professional prior art search up front. And whatever references are found, whatever prior art there is, I would encourage any inventor to include those in the specification of the patent, to actually say, look, we found so-and-so's invention, but ours is different from it in this way, to actually put that directly into the specification. And a good patent attorney will recommend that as well. So there are a lot of costs associated with a non-provisional patent. Finding a lawyer with specific domain expertise. So if the invention is in the field of orthopedic implants, finding an attorney who specifically has expertise in orthopedic implants can save a lot of time, and saving time of an attorney obviously means saving money as well. Really, as an inventor is probably the expert in this field and can help the attorneys to understand what is distinctive about the invention relative to all the prior art. Instead of letting the lawyers guess that and figure it out for themselves, save a lot of time and money as an inventor of working with the attorneys to do that. In my experience, anywhere from $5,000 or so up to $10,000 for a US patent, making that an international patent, PCT, Patent Cooperation Treaty, international patent, adds about another $5,000 to that, so between $10,000 and $15,000. And I think that there certainly is a lot of value towards an international patent, depending on what market space it is. But ultimately, when a patent application is submitted through the PCT process, ultimately countries will be designated at the end. And not every country has the same value. And for example, both Japan and Germany may be big markets for a particular medical device. Prosecuting a patent in Japan is very, very expensive, multiple times what it costs to do so in Germany. And so again, as a new startup, it may be important to weigh what the cost versus the value is at each one of those companies. And something else to budget for in a new startup is annuities. So there are fees that come up along the way, not every year, but typically every few years, in order to keep that patent alive, that a company will have to pay. And oftentimes that first annuity actually becomes due before the first office action. So in fact, you're paying an annuity, paying to keep your patent alive before you even know if you're going to get a patent issued. Somewhat frustrating, somewhat counterintuitive, but unfortunately part of the process. And then ultimately, as I said, if you go the PCT, the international route, deciding which countries can largely affect the cost. If you choose 1 or 2 countries versus a dozen countries, that may largely affect the cost of prosecuting. And not only is it related to the cost, as I said, like Japan, but also the ability to defend. If you get a patent in some country and someone infringes on your patent, now you can actually go to that country and try to defend it in court. So a lot of decisions to make that can affect the cost of the non-provisional patent application. Once that notification of allowance comes, you're going to get a patent. First, celebrate. I highly encourage that. It feels really good to be able to mount a patent plaque on the wall. And then there are ways to keep the patent family open by filing continuations. And basically what that does is allows inventors to keep expanding the claim set and protecting more and more of the invention. And that actually significantly increases the value of that patent as well. And again, a good patent attorney can help with that. So just talked about a whole bunch of things that incur costs for an early startup. How's all this going to get funded? So let's talk about a few different strategies for funding an early stage startup that's just come out of an institution. I think it is very smart for an inventor to wait to raise funds as long as possible, to wait until the value has increased or risk has decreased. By doing that, by having increased value, then inventors are giving away less of the company when going out and raising money. Bootstrapping, meaning the inventors are paying for all the costs out of pocket. That may or may not be feasible depending on the inventor's personal financial situation and their ability to contribute. I had a situation where I formed a company with 3 partners, and pretty rapidly it became apparent that 2 of those partners, 2 of the 4 of us, were not interested in really contributing intellectually and putting in any effort, and in fact got to the point where they were not contributing financially when we had a capital call. And unfortunately, we did not have provisions in our early operating agreement on what that would mean for them. And it ended up turning into a very difficult situation where we had 2 of the 4 of us who were not wanting to contribute anything, and the other 2 who were contributing both time and money, but didn't have a way of sorting the situation out. So again, I'm a strong proponent of having language and provisions in an operating agreement that actually spell out what partner, what an owner in the company, what happens if they're not doing what they're supposed to do. And then to do initial funding, there are several strategies that can be utilized for non-dilutive funding, including I-Corps grants, SBIR, STTR, and competitions. I'll talk more about those in just a second. And then, of course, going out to friends and family, angels, sort of unofficial angels. And what I encourage any startup to do is to work with an attorney and have a formal subscription agreement, even though they're friends and family. Make it formal. I think in the end, it's better for them and you. If things go great and they're going to end up in the end getting a payout, it's really good to have all of this formalized contractually. If things go bad and you don't want to ruin the relationship with his friends and family, you are at least spelling everything out up front, including the risks in that subscription agreement. I think putting in advantages to the investors, like limited founder benefits. In other words, saying going to friends and family to raise money, but not necessarily taking salary as an inventor so that they don't feel like they're just putting money directly into your pocket. And including preferences for especially early stage investors for getting their money back, meaning that if there's ever an exit or a big financial win for the company, that the first thing that happens is that investors get their money back even before the founders might get paid. It's a way to make an investor feel a little bit more comfortable, especially very early stage. I think also putting a modest valuation on an early stage company helps, and not asking people for money and giving them such a small piece of the equity, and then having well-defined milestones on how to grow that valuation. I think these are all things that help to set up a positive relationship with potential investors in the first round, so that they're going to want to come back and be investors in the second round and beyond as well. So let's talk for a second about non-dilutive funding. So non-dilutive funding, these are basically grant programs for getting money in without having to give up any equity. One of them is through the National Science Foundation, NSF. It's the I-Corps program. It is specifically geared towards customer discovery. It's really good for a startup because it's great recognition, gives credibility because these are competitive grants. Not every company is going to get them. Certainly, as intended, will help with customer discovery, validating that the product, the technology actually has some value. And in the formal process that the I-Corps grant takes the company or the inventor through, it will actually help to generate testimonials in the end from customers, which can add value later on for investors. The funding is not huge and it's highly restricted as far as what can be used for. Again, very focused on customer discovery. One other option through the federal government is SBIR, Small Business Innovative Research Funding, or STTR, Small Business Tech Transfer Research Funding. These come from, in the medical field, NIH, but also from other agencies. There are phase 1 and phase 2 grants. They're sort of like seed funding almost, and then follow-on funding. Phase 1 grants range from $100,000 to a couple $100,000, and phase 2 are much bigger. And the phase 1 grants, it's non-dilutive. It's great as a startup company to get a couple $100,000 put into your checking account without giving up any equity. And it's also, again, great recognition. These are very competitive grants, but great recognition and demonstrate the novelty of the invention. And I will, in the future, be giving another talk for leading entrepreneurs of the world about SBIR and STTR funding specifically. And then, of course, working with the institution through institution or regional business plan competitions or other internal programs that are available through the university or the institution. These are great recognition, for a winner of these competition, great networking for business advisors, and oftentimes provide funding or sometimes in-kind services, legal fees, and things like that. There can also be seed funding through universities. This may be dilutive, it may not be, but I think these are ways to take advantage of an institutional relationship if the inventors have maintained their relationship with their institution. So beyond those non-dilutive ways for funding, there's also traditional early stage funding, and those include more formal angels, professional angels, angel networks, and early stage venture capital. And again, one of the things, and I said this a little bit before, is that one of the things that inventors really want to see is institutions acknowledging that IP assignment to the startup. So again, if you think back to my 2 partners and me, the 3 scenarios where the institution gives up all the IP, the institution keeps IP based on the resources that are used, or the institution keeps all of the IP. What we ended up doing is for partner A, we got a letter from the institution to the partner actually acknowledging that policy, and it was addressed to the company. For partner B, again, that was me, in the operating agreement for the company, we actually wrote in there that I would be violating the operating agreement if we used any institutional resources. So basically prohibiting anyone in the company from using institutional resources. And then we got a letter from the institution acknowledging our specific policy and saying that it did not conflict with the IP policy of the institution. From inventor number 3, where the institution wanted to keep the all of any intellectual property that was developed, we actually wrote into the operating agreement that this partner will not and cannot contribute any IP, and that he should keep a separate notebook with his ideas. And that's exactly what we did until we got to a point where we thought it would have good value to the company. We went back to the institution and we actually negotiated rights to the ideas that he might contribute from the institution. And we had different scenarios where we would pay them a royalty if it was a sole invention that partner came up with, if it was a joint invention, or if it was an improvement on another invention. And that institution was happy to negotiate with us. So once having these things in place, then going out and pitching. So for early stage startup, working with business advisors to develop a business plan or a business canvas, there's a lot of different names for this, I think is very important. Generally, if someone is an inventor and they're on the technology side, not having business experience can be very difficult to go out and convince other people to give you money. And I think one good strategy for that, without necessarily adding business partners initially, is to create an advisory board. So put people on an advisory board who can help to give credibility to the company and to share their experiences to help put together these business plans and pitch decks. And my experience is going out and just pitching as much as possible, going to business competitions, startup or networking events, going to colleagues who have experience listening to pitches, going to colleagues who work for big companies that might someday be a potential licensor of the technology, just pitching and learning from the feedback, listening to what they say, listening to what different limitations are. And every different format, every different competition, every different person will have different formats that they want. From 10 minutes where we had to do pitches to screening committees at VC firms and angel networks, all the way up to basically having unlimited time for friends and family. And you see in the cartoon, on the right, I mean, in spirit, it's the elevator pitch, the escalator pitch, and a stairway pitch, and all different versions of the same thing. And I think important as technology people or clinician in the medical space, it oftentimes may be hard to focus on the business opportunity in a pitch, but that's really what investors are interested in. They want to know what's unique about it, but avoid getting lost in the technology itself. So with respect to strategy for fundraising, I think seeking advice before seeking money is really important. And I've learned this several times throughout my career. Someone said to me this very early on, here's a tip. When you ask someone for money, typically what you get is advice. But when you ask someone for advice, typically what they do is give you money. And I found that to be very true over the course of my career. Going out and asking targeted people for money, oftentimes they will refer you to somebody else or tell you what to do. If you go out to that person and say, hey, can you give me advice? Can you tell me who might be a good connection for it? Oftentimes they'll say, you know what, I like this and I'm a good connection for it. Again, I think setting a modest valuation, especially early on, going out and trying to raise money is very important. If the valuation of the company can be based on comparables that are publicly available, that is great when an investor asks you, how did you set the valuation? Otherwise, seeking advice from seasoned investors can be very helpful, and again, from that advisory board. And I think that in my experience, doing multiple rounds of fundraising with modest gains in valuation is a great strategy, again, for keeping investors happy, meeting milestones, and having early investors come back and invest again. And one other thing that's important that I would recommend for any startup is putting together a GUST application. And GUST is an organization. You can go to the website and do it. They help startup companies. And by going through the process of putting together a GUST application, most VCs and angel networks actually start with the GUST application. And by going through all the questions and the queries and providing the information, it's a really good outline almost for a business plan and for a pitch. So I would highly recommend that any startup company do that. All right, so now after going through and doing all of this, filing the patent application, starting the company, licensing the IP, going out and fundraising, how does the company build value? And I think that there are a number of different ways in the medical device space specifically that a startup adds value. And I'm just going to do a little teaser here because I'm going to give another talk on for leading entrepreneurs of the world on building value in medical devices for acquisition. But in short, demonstrating a need, actually verifying that the market is there, looking at defining what competitive advantages the product has, defining a regulatory pathway both in and outside the US if applicable, making sure that intellectual property can be obtained with claims that are meaningful and will protect the invention. Looking at the reimbursement pathway, something very important in the United States. Who's going to pay for this technology and how? That can be critical, and there are classic case studies where there's been great new technology, but no way for anyone to pay for it, and it has epically failed because of that. Finally, demonstrating efficacy and safety as part of the process of getting through the FDA in the United States and being a safe product. And finally, that manufacturing piece. Can it be manufactured, and the cost of goods actually make it competitive? So I'll talk about these things. This is the basis, the outline for a future talk. But just in summary for what I talked about today, I think it is possible to balance academics and a startup. It's not an easy balance. And I think one of the big challenges there, and something that I've experienced, is making sure that I did not let performance slip on the academic side, that I made sure that I was meeting all the benchmarks and the criteria to be successful on that side, and then also making sure that I was not the bottleneck on the startup side either. I think probably this is the most important thing, is complete transparency is absolute key. The last thing that I wanted to do was either A, get fired from my institution, or B, set up a problem, potential lawsuit or liability with the startup company because of something that I didn't disclose. And so I have been very diligent, and in some cases maybe overly so, in making sure that I was transparent on both sides. And that conflict management plan can be absolutely key. And what I have here is think witness box. I've heard of colleagues who try to sneak things, do this and that, and do things that might be, just in the gray area of what is okay to do and what's not okay to do. And I've always thought, if I'm ever in the witness box in a lawsuit and I get asked a question, I want to be able to tell 100% truth without having to jeopardize any relationship with the institution or the startup. I think putting an operating agreement in place at inception is super important. Attorneys are not cheap, but I think the value that they bring is absolutely worth it at key points in this process. I found that surrounding myself with the right people who are absolutely committed, who have the same values, same moral compass that I do, not people who might be inventors and don't really care about the commercialization and the entrepreneurship process. So I think this can be key to an inventor's sanity, who they're working with, and also the success or failure of the startup itself. I think the provisional patent is an incredible tool for building value for a startup. $75 or so to file, no attorney necessary, and just including lots of embodiments can offer a lot of IP protection. And building that IP portfolio is really key. That's something that can be done early on without a whole lot of funding and resources, but adds a lot of value later on. I think seeking non-dilutive funding is a great strategy for as long as it's feasible. Between bootstrapping, grant applications, and small pots of money that might be available through competitions, this can help to build value and help the inventors and the founders to actually hold on to some equity. And I think evolving the technology and developing that MVP to actually show and demonstrate is really important. Doing that as soon as possible, doing that long before going out and seeking investment to help raise valuation and reduce risk. And finally, with respect to the pitches, I found, that there are certain people that get really excited and end up not investing at all. For certain institutions, they get really excited, do their due diligence, and comes back positive, and nothing ends up happening. And then other institutions or people who generally, you're outside of their space, their domain of expertise, and yet they come in and they're very interested in investing. So in my experience, being patient and tenacious with the pitching has been a recipe to success. So hopefully this was informative. Hopefully these things for an early stage inventor working in an institution can be helpful for actually bringing a startup to fruition. I'd like to thank leading entrepreneurs of the world for inviting me to give this talk. I'd like to thank my collaborators and mentors over the 25 years of my career, helping to share their wisdom with me, and my current employers, the Center for Disability Services, and my startup, ReVivo Medical. So thank you very much.